So today we're going to talk about the criminal procedure revolution, and thinking about crime and crime control in the 1960s raises very basic historical questions, the kinds of historical questions that you all want to be thinking about every class session, even if we're not talking about them. They're the kinds of things that you should be thinking about overall in the class as you're trying to bring together the various topics and themes. So the first one is change over time. What does the before look like and what does the after look like, right? Where are you moving from and to what extent is there change and in what ways? Second, we're going to talk about causation. Why does this change happen? Not causation as in we will come up with one cause that leads to everything, but thinking about the various kinds of causes and what kinds of historical inquiries you're making when you think about those different kinds of causes. Are there intellectual historical causes, political, social, those kinds of things. And then finally, we're going to talk about the role of the court, and the kind of sub-question that I think of there is, did the Warren Court make a revolution? And there are a couple of aspects to that question. What is the role of the court in this history? Before we start talking about these three questions, though, I just wanted to say one thing, and I don't imagine that we will succeed in the aspiration that I'm about to put forth, but I'm going to hope. And that is, it is very difficult, I think, to talk about this subject the way that Larry Kramer suggests. Remember Larry Kramer from the very first class? That we should think about history, right? It's very hard to be a tourist in this time and to think of yourself as a traveler who's trying to understand what folks are thinking of, because we know the end of the story. And so when I say I want to think about change over time, I want to think about what changes in the 1960s. What is the world of criminal justice like before the 1960s, and what is the world of criminal justice like after the 1960s. But by that, I don't mean the 1990s or the 2000s or the 2011s, right? Because there has been what has been called the retributive turn in criminal justice. And one might say, you know, the pendulum has swung back. One might say it's cyclical. There are lots of ways to think about what the relationship is between current criminal justice practices and, say, pre-1960 criminal justice practices. I, for one, don't think they're the same, and we can have a conversation about that some other time. But I do want us to try to think, what was it like in the 1960s as this was happening? What did it look like was changing? Where did people think that this was headed without being weighted down by our knowledge of harsher criminal penalties, massive incarceration, a burgeoning of substantive criminal laws. So let's try to do that and to keep Larry Kramer's admonition in mind that we're trying to be travelers to this time and figure out what people were thinking about then. All right, number one, change over time. What do the before and after look like? So let's start with the before. How do you describe criminal justice in our before? I gave you a few different things. I gave you the field interrogation guide as one obvious place to start, but you can glean from other readings what the before looked like too. So why don't we start with field interrogation? What is the before that this describes? Was any of this striking to you in the way this police sergeant is suggesting police officers get trained? Matt.
I was sort of surprised that the police were instructed to try to determine the character of the citizens. So in advance, they were supposed to decide whether a person was likely to have committed a crime or not. And that's sort of maybe what I would expect now, with trying to treat people equally and not assume that they did something bad in the past that they will commit a crime again.
And is the question that the police officer is asking whether this person is likely to commit a crime or not? What are the labels that he uses about these folks? At the bottom of page 246 of our course packet, responsibility of the policeman. What is B? Read us B, 1B.
He should have a knowledge of the legitimate or illegitimate nature of persons who pass through his jurisdiction.
So do you think that maps on precisely the legitimate or illegitimate nature of persons? Does that match on to the way you said it, which was people likely to commit crimes?
Not quite.
So what's the difference, right? You read it, right? You read it from a post-1960 understanding, right? Which is, what are police looking for? They're trying to find the people who might commit crimes or have committed crimes. Is that what he's looking for? What's the difference between the way you put it and the way he puts it?
I mean, I think he puts it like these are good people with bad people. Like they're starts the opposite. Not that they're someone who commits one crime at one time, but legitimate or illegitimate as a moral character.
And what makes someone a bad person? Is someone a bad person because they committed a crime or because they are likely to commit a crime? Or does the category of bad person go beyond their criminal propensities?
I think it goes beyond.
Good answer. But in what way? How? How do we know? What does he tell us about the process of field interrogation that suggests that this isn't just about criminals?
He talks about legitimate businessmen and merchants, and so there are certain people in society that are contributing to the economy and have a better reputation.
Yeah, yeah. And who are the others? Look on page 248. Under 5, selection of subjects for field interrogation.
Emaciated alcoholics, narcotics users.
The unusual. Persons who do not, quote unquote, belong where they are observed. Automobiles which do not look right. The unusual. If you are unusual, you are the subject of a field interrogation. There was a fabulous outcry in late 1950s San Francisco when the Calaveras County had something called Pioneer Days. And so all these folks from Calaveras County were dressing like pioneers, and they were wearing beards. And a bulletin went out to the police force that said, don't arrest these guys with beards because they're doing Pioneer Day. And the implication was police officers were supposed to arrest others with beards. Because if you wore a beard in 1958, you were a beatnik or some other kind of subversive character. Because people didn't wear beards, Josh. They really, you don't think you're necessarily making a subversive statement. But in 1958, in 1968, it was a subversive statement. There's a whole series of cases about facial hair and length of hair for men and whether these are rights that one has to engage in. If you were unusual, you were illegitimate. The language, you see the language that's being used here, Trevor?
Well, I think it's interesting if you look at the perspective, though. It's obviously clearly very localized, but it speaks to something you have to frame within a context that involves no cell phones. The interstate highway system is only 7 or 8 years old. People do not travel as extensively as they did, and communities were much more homogenous. So I think that compared to the interaction that everyone in this classroom observes today, just in Charlottesville, the situation in which this person was writing is extraordinarily different.
So I think that's correct. Although the situation which he's writing is for cities that are actually experiencing influx of people and becoming much more cosmopolitan. There's much more mobility than there had been in the past. But you are right that a lot of the professionalization of the police force in the 20th century, the move to a professionalized police force in the first place, the move to professionalize that police force more so than had been the case, is a response to immigration. It's a response to migration. It's a response to industrialization and the sense that there are threats, right? So what I'm trying to point out here is what are the nature of the threats, right? It's not crazy for a police officer to say somebody who looks like they don't belong in a neighborhood may be up to no good, right? And that's clearly still the case. But the question is, what makes someone look like they don't belong? What are the characteristics? How do they appear to be illegitimate? Were there other things, Shalana?
Well, what I found interesting was that at the end of the list, he said, like, well, how about your own personal experiences to add, like, to the list, which definitely is like an open door to just, like, let those prejudices just come out and, act upon those.
Your prejudices are good, right? You have prejudices for a reason because you're a police officer. So if you think X category of people is likely to be committing crimes, you're probably right. You're absolutely right. It's an invitation to prejudice. David, was that a hand?
Well, it's not so much though about like just who to select.
That's okay.
But one thing I find interesting is on 247, the prevention and repression of crime, it says basically that they're trying to create an awareness of the omnipresence of the police, which seems sort of interesting. I guess when you think oftentimes about, sort of the role of government and police and everything, oftentimes the fear is this sense of omnipresence, whereas here we basically have this idea that, well, that's what we're looking for, to create this sort of total sense that everywhere you are, somehow the police are watching. So I thought that was very interesting.
So as opposed to when the police are watching everywhere, you live in a police state, and that's what we should avoid. He's saying, no, that's the goal, right? The omnipresence of the police is going to prevent crime, right? Josh?
I thought it kind of struck me as like type of policing, and I think it's telling in that it is like Trevor said. Name's Trevor, right? Mm-hmm. Yeah, it's like that in that the officer is thinking, oh, this is like a really small homogeneous community, but it's not anymore, and they're trying to apply this theory of how to be a police officer to like Oakland. I think that's where it is, right? Somewhere.
He's in Santa Ana, yeah.
Okay. It's like big cities in California, which are not like, some 800-person town that is idyllic, and all these ideas like, no, all the people in your city, but it's going to be impossible, so just try. And it's all of these things, they seem like a great idea if you're in that small town 1950s, perfect bubble, but not, so they seem ridiculous.
And what does he say, though, about, know everybody, but if you can't, what do you do? Strangers are presumptively problematic, right? So you know everybody, and the people you don't know are even more suspicious, right? Among the locals, you've at least sussed it out, and you can figure out who's legitimate and who's illegitimate. But when somebody new comes in, then you gotta worry about them. Although I would wonder, and I think you recognize this in your comments, right? When you say Andy Griffiths-like, right? Is there really such a place as the 800-person homogeneous town where, everybody is the same and the police are policing in a, aw shucks, we're on everybody's side kind of way, right? So in my experience in my vagrancy research, there's always an outsider, right? There's always either an outsider embedded in your community, racially, socioeconomically, religiously, culturally, or there are outsiders coming through or coming in that create problems, right? So I think you're right. He's imagining a place and his policing is not being applied to that place. But I wonder if that place is an imaginary place, even from the get-go. Callie.
Oh, I was just gonna say, building up that the part I thought was ridiculous. It was when he's talking about you should even know when people walk their dogs and how could you ever know that much detail about every person in your neighborhood? And I found that really intrusive too, of what is where I walk my dog have to do with fighting crime. It had to sort of big brother.
So again, the David's point, right, that this is the police state. If the police officer's going to know when I walk my dog. Now, the other response to that would be, that's reassuring, right? That's what he's saying is this should be reassuring if you are a legitimate person. If you are a law-abiding person, then what you want is for me to know you're out walking your dog. This is when you do it. You're not up to no good, but that guy over there who's walking around at 11:30 at night, he isn't legitimate, and I'm going to prevent him from assaulting you, right? So that's what his understanding of the role of the police is, to make you feel safe with the omnipresence of the police. And I think our sense of safe police state, right, is a sense of that was the before, right? That's a world that a lot of us can't relate to. Max.
Yeah, I don't know if anyone else picked up on this, but this whole thing smacked very strongly of the kind of 1950s, early 1960s paranoia about communist infiltration and subversion. And it doesn't seem that he's specifically concerned with communists, but that kind of idea that, everywhere there's a lot of nationalism. We don't know them, but they're everywhere and they're out there. And the whole thing kind of, seemed in that light to me, which is ironic given what people have said about how, and I agree with this, about how eerily Big Brother some of this is, given all the antipathy for the Soviet Union, everything it stood for.
So there's a sense of threats. Now, to be fair, right, he's a police officer. This is a moment, as you read in your readings, of rising crime. It is the case. There's a lot of scary stuff out there, and he feels threats. Now, I think that's true, and I think you're also right. It's very hard when you read this. It's hard when you read criminal justice history generally. It's very hard to disentangle real threats from the perception of threat, right? And there were real threats, right? And a lot of the unusual people do pose real threats. And we can ask the question, what do we mean by a real threat, right? And one of the things that doesn't come out all that much in your readings, but one of the themes of criminal justice history in the period before this period that we're talking about is the move for police forces from a kind of morals regulation and social control to a crime control model, right? And that real threats include threats to the social fabric that we today don't necessarily think of as crime. But that's part of the before, right? Sodomy is a crime, various kinds of sexual encounters are crimes, vagrancy is a crime, right? There are all these laws out there that public drunkenness, although that's still a crime under certain circumstances, but it was way broader in the before period. Morals offenses were much more widespread and were perceived to be real threats in a way that we discount and say, no, the real threats are just violent crime or property crime. Benita.
I think that the fundamental difference between the before and after isn't necessarily, of course there's changes in how he views different people, but I think it's underlying that is, does he give those same people, like does he give the businessman and the stranger, I guess, the same rights? Do they get the same procedural rights later on? I think that's the change that's happened over time. You know, do we train the policemen to say, okay, these people are treated the same and they get, you know, the same idea of privacy, I guess, or do we tell them it's okay to target these people and not worry about the other people?
So what else does our before look like? And that's a great segue, right? What else does our before look like? One thing we have is a sense of what policing techniques look like. Field interrogation is incredibly popular. You see it come up in Terry. Stop and frisks are a variant on field interrogation. You see it in the memos about aggressive patrol. This is not just one guy in Santa Ana, California. This is a pervasive form of policing. So what else do we know about the before? What do our criminal justice procedures, laws look like? Philip.
Something I got from just the way that he drafts this article is that the structure in which these police were operating at the time was different. That while you don't have the Andy Griffith, small, idyllic 800-member town, you get the sense that you do have police officers who have very regular beats, who are always in the same neighborhood. And so you can be in a position to get to know the people in your neighborhood. But he also notes that that's changing. One of the problems that he identifies with implementing the techniques in his article is that police officers are being put on more varied beats and that towns are getting larger. So he's contemplating if there's a change from sort of small town or consistent life to this much more urbanized system.
And technologically, right, he mentions technologically, motorized patrol is a problem. Police officers in cars don't have the same access as police officers on the street. Police officers responding to calls, 911-like calls. I don't think it was 911 back then, but to calls for service are being diverted away from the beat patrol. So we've got other changes. So let's think about also not only what we see in field interrogations, but what we learned from the Wilrich, what we learned from the Anthony Lewis article and how he describes what happens to Gideon, right? What else can we suss out of these things? Jesse.
There was wide variation over states as to what kind of process was available. So you had some states that were already, as a matter of state constitutional law, providing public defenders and process, whereas you had other states that were much more localized or variant.
Right, incredible variation, not only across states, but across localities. How constrained are police officers by constitutional law in the 1950s? Very constrained, not constrained? You can all say it together. Not constrained, right? Like, not constrained. This is not, when he's thinking about what can we do as police officers, he is not asking the question, have the courts told us there are things that we can't do? Are there certain things that we can't do? That is not part of his understanding of what constrains the police or what the police are authorized and enabled and empowered to do. It's just not part of the conversation in a meaningful way, partly because this is all being done at the local level, partly because it has not been thought of to a large extent as constitutional questions. Other things about the before. What about, so we know about police officers, we know about lawyers, Jesse mentions. What else? Sarah?
I think from the Wilrich, you see a shift away from seeing a criminal as like an individual sole bad actor outside of the social fabric towards moving towards a more scientific understanding that criminals are individuals within society, and that society has effects on criminal behavior, and that there's a relationship there.
Mm-hmm.
That needs to be recognized in some way as best as possible.
Right, the social scientific turn, the social deterministic turn, that people are criminals because they're made criminals by society as part of the before. And how integrated does Wilrich think that those ideas are in the actual processes of the criminal justice system? Does the criminal justice system in the before do a good job of then treating folks as if they are creations of society?
No. I think the idea is certainly there, but it's difficult to do that, and I think he treats the before as a pretty harsh, draconian sort of rule.
Right. The before, there's all this rhetoric about social determinism and rehabilitation and social responsibility for the criminal, but in fact, according to Wilrich, the regime is incredibly harsh. It's incredibly strict. It doesn't actually implement what one would think of as reforms that would make the social determinist ideas come to life in the system itself. There are a few other things that I wanted to mention that don't come out in your readings that I think are important parts of the before. So in addition to there being very little oversight of what the police do, there's very little oversight of the judicial process itself. Part of that has to do with counsel. Part of that has to do with what local courts look like and how they operate, especially low-level local courts, police courts, magistrates courts, justice of the peace courts, where crimes like vagrancy, public drunkenness, prostitution, disorderly conduct are being heard. And there's a wonderful article that I highly recommend if you're interested in this kind of thing by a guy named Caleb Foote, who was a professor at the University of Pennsylvania Law School. And he writes this article after having sat in the Philadelphia magistrates' courts for months at a time, watching how they operate. And what he reports is that 60 men, pretty much always men, 60 men would come into the room. The judge would tell them to stand. He would look around them. He would say, you're in a collared shirt. Maybe you have a job. Do you have a job? And if you said, I have a job, he'd say, all right, you go, but I don't want to see you back here again. And then he'd look around some more and he'd say, the rest of you, 60 days in the workhouse. And that was it. That was it. That was it. There were no lawyers. There was no notice of what the charge was. There was no opportunity to defend oneself. That was it. And in fact, there was one, he cites one thing that at one moment, there were something, I don't know, there were 1,500 vagrants in the workhouse, but there were only 1,000 convictions for vagrancy on the books at that moment, right? So nobody cared about what the charge was. Nobody cared about whether you were going to defend yourself from the charge. And this was incredibly common. There were some justice of the peace courts in which the justices of the peace were paid if they convicted you, but not paid if they acquitted you, right? That's a real before story, right? You can't imagine that story today. They were paid, although we do have the police officers. Yeah, we have the police officers who are planting drugs on their suspects in order to make their quotas. You're absolutely right. But we do not have courts anymore in which officers are paid if they convict and not acquit. But you're totally right about that. You did miss my conversation at the beginning of class in which I said we're going to try to hold in abeyance what's going on today. But it's irresistible to mention. Yeah, it's irresistible. Lyle.
What was the workhouse?
So the workhouse was a prison in which, and the workhouse comes out of 19th century ideas about the immorality of crime and the need to instruct people in the good habits of hard work. And so it's a throwback to 19th century early prisons in which work was the touchstone ideal. And workhouses were only used for people convicted of these low-level crimes. They were often they were a form of prison where the idea was that you work. And they were called workhouses, and they've largely, I mean, we still have prison farms, we still have lots of prison labor, but we don't have these particular institutions so much anymore. Are there other things people want to raise about the before? Anita.
I just thought the comments about the prisons themselves was interesting, about how there wasn't any kind of oversight on state institutions, but I think it said by 1995, 41 states as well as D.C., Puerto Rico, and the Virgin Islands had at one time been under court orders. So and so they were telling them things like how large the cell could be, and just thinking about that I think is really interesting. I don't know if we would see that necessarily today, except for when they've determined that there's too many people in prison.
Right, and partly why we don't see that today is because in the 1990s there was a Prison Reform Litigation Act passed by Congress that made bringing lawsuits against prisons much more difficult. So Congress responded to this incredible federal court supervision of the state prisons, as well as a huge increase in prisoner litigation in general, not just on a large scale, but on an individual scale, and so that has stopped. But you're right, prisons, not that they're lovely places to be now, but prisons in the pre-1960s era were pretty horrific. There wasn't the Eighth Amendment was not operative in the prisons in the sense that anyone would say the conditions of my confinement are unconstitutional. That is not happening in the 1950s, and the conditions of their confinement for many people were pretty awful. So I think that's a good point. Garrett.
I feel like the shift from the before to the after. I mean, that there's certainly procedurally and court-wise, there's been a big shift, but I just feel like as far as how the police operate, there really isn't that big of a paradigm shift from before to now. I feel like they can't use these terms exactly, but I mean, in most communities, I feel like this is still what they do. And I feel like now, I mean, this is a law school, so we kind of react to this police state reaction, but I feel like if I gave this list, and most people from where I'm from, in my community, I think 90% would love this list, would encourage the police to use exactly this. Now, maybe not use these terms, but to prosecute and single out these exact people. So I don't know if the shift is really as big as before to after that.
So this is why I want to hold today in abeyance, right? Because what I want us to figure out is, what did this shift look like in the late 1960s, right? When this shift is just happening. Because I think there have been real changes over time since that moment. And it's possible that the folks in your town would like this in 1968, they would vote for Nixon, right? That there are always folks who like this list. And I think that one of the main difference is, if I could say it this way, is that there are always folks who like this list. There are always folks who don't like this list. But before the mid-1960s, the folks who didn't like this list had almost no power, right? They were the people targeted by this list. And what happens in the late 1950s and 1960s is people with power, elites in the legal system, legislatures, scholars, don't like this list. And that's where the change happens, right? It's not the case that this list goes away, or that this model of policing goes away, or this model of policing doesn't have defenders anymore. But suddenly there's an alternative model of policing, and maybe not so suddenly, but there's an alternative model of policing, and then you have a competing views of what the criminal justice system should do and how it should work. But I take your point that it's not as if the whole world is going to say, this guy's crazy. They're not, right? That's a lot of what we expect the police to do still is the case. Last comment, and then we're going to move on. Yes, Chris. Yeah, sorry, that was you.
Great. I guess I wanted to just bring up something that was mentioned briefly. They talked about that Weschler law review article about there was a lot of strict liability offenses. I don't know how many offenses were strict liability, but it seems like that was important, and that kind of showed that the courts didn't really care too much about the individual. Not having a mens rea requirement just kind of doesn't take, it kind of takes away any sort of like particulars of that situation.
Absolutely. I think that's a great thing to add. And to put a little gloss on that, right, it's not just that the procedures of criminal law are different in the before period or the sanctions, which Sarah was talking about. It's also that the criminal law itself, what was prohibited and how it was prohibited, was also different, right? So I think Wilrich mentions this, but you want to think that when we're talking about a criminal justice revolution, there are three potential aspects to it, right? One is, what does the criminal law say, right? What are legislatures passing as the criminal law? The second is, how do procedures work? What happens on the street? What happens with police officers? What happens in courtrooms? And then the third is, what do sanctions look like? How does punishment change? What does punishment look like? So I think that's a great point. All right, what's the after then? We've started sort of getting into the after a little bit, but what's the after? How does all this look different after? Lyle.
I think it's more of an emphasis on social benefits. Cause crime, you see people talking about rehabilitation, punitive punishment. So I think there's obviously a scientific and a moral shift in how we treat criminals and what we want to do.
And Wilrich suggests, right, so this goes to Sarah's comment, and one thing that I think I want to point out is not everything has changed, right? There's continuity too. So this idea of rehabilitation clearly existed before the 1960s. What the Model Penal Code does is try to coherently integrate ideas of social determinism and rehabilitation into a penal code that also talks a lot about individual responsibility and mens rea. And so one of the things that happens, which is sort of at a high level of theorizing, right? But one of the things that happens is things that were at odds in the past, which are still somewhat at odds, right? It's a little bit at odds to say crime is socially determined and to say you're not convicted of a crime unless you're culpable, but how are you culpable if crime is socially determined? One of the things that happens is there is a greater integration and a greater attempt to create coherence there, but I don't want to suggest that everything has changed over time, partly because of what Garrick says, and partly because a lot of the ideas that get entrenched in the 50s and 60s have been percolating for some time and have been moving around and instituted in various places. There have been some reports in the past, and then they get entrenched more now. What else? What else is the after, Josh?
Kind of building off of that, there's a move towards greater uniformity, just an application of constitutional law, regulate state law.
Yeah, greater uniformity. This is one of Wilrich's big points, right, is greater national uniformity, partly because the Supreme Court gets involved, and so you do have national constitutional level restrictions on what police officers and courts and states can do. And partially you have more national uniformity because of the Model Penal Code, and lots of states following the Model Penal Code, which creates more uniformity. Callie.
And building on that, I think there's a shift in seeing local actors as state actors too, and realizing that people need to be protected from like their local government and local courts just as much as against like a big federal government.
That the federal government can be rights protecting and not just encroaching, and in fact maybe should be rights protecting against local norms, prejudices that are thought to be increasingly problematic. Amber?
Some things were decrimified, so if you had violations that you can fines for instead of being all lumped into this crime bucket.
So this goes to Chris's point, right? The strict liability crimes, that changes, and there's decriminalization of lots of things, and some of that is total decriminalization, and some of that is the creation of administrative or civil sanctions for certain kinds of offenses. David?
You also, though, have a court system that's having a lot of trouble adapting in many ways to this. I mean, Warren talks about the backlogs that are being created, how, like, in one district it's taking about 2 years between indictment and trial, and the problems that having. So you see how this new system is really posing a lot of new problems that we don't really see how there's going to be any adaptation to.
Yeah, procedure takes time, right? Procedure takes a lot of time. There's a case in 1960 out of the Louisville police courts where this guy, Sam Thompson, wants procedure. He wants a trial. He wants a lawyer. He wants to contest the charges against him. And what Louisville responds is, these police courts see 25,000 cases a year. We can't give all those people a trial. We'd have to change our whole system. And in fact, one of the things that happens, right, is a huge increase in plea bargaining, right? If you require more procedures, you can't possibly give all those people procedures. And in fact, mostly we don't, right? The vast majority of cases are decided by plea bargain and not by a trial. So I just want to get on the table the Supreme Court cases. I'm still only on page 2 of 14. This is problematic. And it's not your fault. I mean, you have great things to say, but it's my fault. But just to get on the table the cases, right? So you've got a whole bunch of cases regulating the police. Cases like Mapp v. Ohio, which established the exclusionary rule. Miranda v. Arizona about warnings. Escobedo v. Illinois is about the right to counsel during interrogation. You've then got a whole bunch of cases that regulate the courts. So there are cases about transcripts for appeals. This case, Griffin v. Illinois from 1956, is one of the earlier cases that if an indigent couldn't afford to get a trial transcript, then the state had to provide it for him. There are cases that open up federal habeas relief for state prisoners, cases that change due process standards, say for juveniles in Ray Galt, that's mentioned in your readings. There are all the prison cases that bring state prisons under federal jurisdiction and really do, as Benita was saying, really do change the way state prisons are run as a result of findings of Eighth Amendment violations of cruel and unusual punishment. Also, the Justice of the Peace Courts I was talking about, those are challenged and those are largely eliminated where, not all Justice of the Peace Courts, but the ones where they get paid for convictions and not acquittals, that goes by the wayside too. So I just want to sum up the sort of before and after with a description from a book. And if you're interested in this stuff, this is a real classic book by a guy named Herbert Packer called The Limits of the Criminal Sanction. And in this book that he writes in, I think 1968, he describes two models. And this goes back to what the conversation Garrick and I were having before. So he describes two models of the criminal system. And the old model he calls a crime control model. And the crime control model assumes that the repression of criminal conduct is the goal of the criminal process, right? Repressing criminal conduct, preventing and repressing it. And that the failure of the repression of crime leads to disorder. It leads to a breakdown of public order, and it leads to ultimately the opposite of what David and Callie were saying, that without public order, you can't have human freedom, right? So you need a crime control model in order to make the world safe for people to exercise their liberty and freedom. And the crime control model views the criminal justice system as an assembly line. You get somebody on it and they go through all the steps, and the goal is to convict them at the end of the day, because by the time they've gotten on it, you think they're likely guilty of the crime that you think they've committed. The new model he calls the due process model, although some have said after he wrote that's a little bit of a narrow way to think about it, because as we were talking about, it's not just about due process, it's also about the kinds of laws states pass, it's also about the kinds of sanctions that one puts into place. So it's not only procedural. And the due process model assumes that the loss of liberty one experiences in the criminal process, the stigma of being brought into the criminal process, is the heaviest deprivation the government can inflict on an individual, right? That's where harm lies, is in the government pulling somebody in to the criminal process. A criminal process, says this model, that is unreliable, subject to abuse, subject to prejudice, subject to inequalities, and that they view the criminal process, or they think the criminal process should be viewed as an obstacle course, right? So that at each stage, The government has to make out its case at that stage. Probable cause, guilt beyond a reasonable doubt. They have to make out their case for why they have the authority to do this horrible thing to you. And the goal of the due process model is people are falling off the assembly line all the time due to this obstacle course. I've just mixed the metaphors, right? But that's the way this is thought. Now, I want to say, right, and this goes to what I was talking about with Garrick, right? It's not the case that the due process model enters and takes over everything and suddenly you have a new paradigm and nobody is attached to the criminal control model, right? People are very attached to the crime control model, especially police officers, prosecutors, state legislatures, right? There's an incredible attachment to that model, and they fight tooth and nail, which we see, and we're going to talk about in a minute. All right, so we've got our before, we've got our after. We're all comfortable before and after. Why does it happen? Why, even though the crime control model continues to exist, why do we get this new model? Why does it become more dominant? Why do we get what is often called the criminal procedure revolution or the due process revolution? I think there are a bunch of different answers that we can see in the readings. Emma.
I think the fears of totalitarianism, sort of in the aftermath of fascism and everything, was a big factor in terms of sort of looking inwards at our own procedures and, you know, the repression and inequality that we have in our own system, and how that could endanger democracy or even just make us look bad.
So there are international pressures, right? There are both international legacies, right? So of Nazism, fascism, and international pressures ongoing at the moment in the Cold War and the fight against communism that lead to some of this change. I think that's absolutely right. And you want to think about it. It's interesting, right? The Willrich is a very recent piece, and you can see the influence of the international turn that we've been talking about in that piece. That would unlikely have been there in a piece written 30 years ago, right? But he is attuned to the idea that we are part of an international system, a global world, and we should think about how those tensions operate here. Other thoughts about causation? Josh?
Well, it seems like there was at least in Gideon's case, there was a growing consensus among the states that these types of procedural rights were a good thing to grant people, like Britain, history that's not that one of these states demonstrates that.
So that's to say that the court is not acting in a counter-majoritarian way, right? So if we're thinking about this as a judicial revolution, it's not just a judicial revolution, right? It's actually much broader than that. So why is it? What's happening? Why do the states think this too, and not just the Supreme Court? What's been happening that has led so many different kinds of people in this direction? Trevor.
I just want to ask a question. This came to me when I saw the challenge that was made on Gideon's case after it went back to Florida. To what extent does the proliferation of the legal profession and the fact that these cases are actually able to get to the Supreme Court because there are more available attorneys to handle them? I mean, like you said earlier, the Philadelphia context is correct. Prior to the 1960s, you get 60 people convicted at once. That was probably fairly common in the suburban area or the urban areas across the United States. How much did the nationalization of transportation, air travel, communications play into the mass proliferation of attorneys in terms of producing these kind of cases? Because normally there wouldn't have been any business in it.
The population of lawyers in the United States goes up steadily throughout our history, right? And in fact, it does increase a lot in this period as a result of the GI Bill, the democratization of the profession, allowing in more immigrants, more women, more people of color, although these are still, although the number of people of color who are lawyers in the South is still shockingly low. I think there's, 1 or 2 lawyers in Alabama in the 1960s, black lawyers. So that's part of it. But part of it is They get jobs because of this revolution, right? Most UVA law grads do not go out and hang up their own shingle, right? But if you did, one of the places you would get your first business from would be court-appointed criminal cases, right? That's one of the things that happens. And the same thing is true with legal services, right? So legal aid gets established in the 1960s. And that's, partly there are more lawyers available, but it's partly a new commitment to the way we think about the justice system and who deserves representation that then creates whole new swaths of the legal profession that lawyers fill.
And I would argue those two are tied together.
Absolutely tied together. Chris?
I think kind of the civil rights struggle that's going on, and just like for I guess a couple of classes, we've been kind of talking about like the court's kind of role as protector of civil liberties and how that's been going on. That kind of thing's been going on for decades and decades. So that kind of enabled the court to kind of bypass the traditional federalism concerns about like prisons and things like that, and is typically an avenue of the states. So I think that thinking.
Absolutely, right? This is part of the race revolution, right? This is part of the civil rights revolution. The court clearly thinks that that's the case. Advocates clearly think that that's the case. Was anybody struck by the NAACP's brief that talked in a brief about Terry v. Ohio? What are they talking about? Interracial couples, right? The whole thing is, there's more of a brief. This is why they're interested in this case, right? It's all about interracial couples. Why is it all about interracial couples in 1967? What happened right before this case? Name a case from common law. Yeah! Nice work. Loving, right? The court has just said, you can't criminalize interracial marriage. And they come back and they say, okay, but if you don't criminalize it, this is what cops are doing now. This is what states are doing now. Maybe they won't criminalize it, but they're going to arrest them and harass them and make them crazy. They're saying to the court, this is all part of the same thing. And the court knows that, right? The early cases that come up a little bit in your readings from the 30s, from the Scottsboro incident, the first times that the court does dip into constitutional criminal procedure and reverse what state courts are doing with regard to criminal cases is in the case of a highly publicized, highly racialized incident, the Scottsboro case from 1930s Alabama. So it's absolutely the case that race is coloring this to a tremendous extent. That's a big part of the story. Jesse.
And I think just kind of underlying all of this is the growing temptation of state for federal government to act. So the argument against the incorporation of the Bill of Rights is becoming less salient following the New Deal revolution.
Absolutely, right? And Will Rich points this out, that there's much more federal capacity and there's much more acceptance of the federal government playing a large role in lots of aspects of life. That starts with the New Deal, continues into World War II, is a part of the idea of the Great Society under Lyndon Johnson, right? The federal government is more present, and the Supreme Court in particular is more present. John.
Also, the general societal rejection of the Vietnam War. Got protests everywhere. Johnson said he's not going to run in 68, so there's a huge political backlash all over, basically anybody from 18 to 36.
And how does the criminal procedure revolution relate to that?
Well, you're going to have riots, you're going to have mass groups, people downtown the mall, for example, and the policemen see the large group of people coming in and out of the town on the way to DC and assume I would arrest somebody or something like that.
Right, there's general upheaval, although I think it cuts in multiple directions, this general upheaval, right? I think it's part of why the court does what it does in Terry as well. But as a general matter, yes, I think it's not just the civil rights movement, it's other social movements, it's political movements, it's a youth revolt, partly in response to Vietnam, partly not. What if you were an intellectual historian? You were a legal and intellectual historian, like, say, Will Rich. What else would you point to as causal here? We already talked about it in the before and after, but I want to get it on the table as part of the cause, because I think it's easy to just say it's just context as opposed to having any causal relationship itself. Emma, was that a hand?
Well, I don't know if this is what you're looking for, but how we were talking about the rise of like social sciences and social determinism, I think that shift in intellectual history is pretty huge in terms of not just necessarily having this black and white view of government, the police are good, and everyone who gets arrested is bad. I think shifting from that black and white view and being a little more skeptical of, good and bad actors, I think that actually has a huge effect.
There are huge changes in intellectual trends, right? And it's not only among social sciences, which is one of the differences, I think, in this era. It's among legal elites, right? It's law professors. The ALI that creates, the American Law Institute that creates the Model Penal Code, they're not crazies on the fringe. They are the mainstream elite of the legal profession saying, we can't run criminal justice this way anymore. This is totally unacceptable. And part of that comes out of social science studies. In the 1950s, you see tremendous studies of how criminal justice systems actually work. And the view that comes out of those studies shocks a lot of people. And they say, wow, we didn't realize that the police did this kind of thing. We didn't realize that courts operated in this way. We didn't realize the corruption, the prejudice, the inequality, the injustice, and we have to do something about that, right? So one could say that the scholarly turn is a reaction to Nazism and totalitarianism or the civil rights movement or anything else, but it has its own heft as well, right? And that's something that Will Rich is really emphasizing, is when you're thinking about causation, you want to think about there are all these different streams, and they're all, in this case, not all of them, because I think John's are pushing sometimes in the opposite direction, but many of these streams are pushing in the same direction. Philip.
I think it matters who the personnel on the court is. I mean, the sorts of things that you see in the War and Revolution look very, very different if you have a Chief Justice Byron White instead of Earl Warren. They look different if you don't have William Lennon sitting on the court.
So you're saying causation is in part a function of the court itself and the justices on the court? Nice. Segue, number 3, roll the court. Thank you, Philip. That was so elegant. Okay, so let's talk about the role of the court. Did the Warren Court make a revolution? And I named this class session the Criminal Procedure Revolution. But part of me thinks I should have named this class session the Criminal Procedure Revolution ? And I think there are 2 reasons why there might be, I love question marks, why there might be a question mark at the end of that title. So I'm going to introduce them and then we'll take them one at a time. So the first is questions about whether the Supreme Court made a revolution, right? What was the Supreme Court's role in crime control? Did it create a revolution? How central was it to this change? And then second is, well, was the Warren Court still creating a revolution at the end of the decade, even if you think that they were creating a revolution at the beginning of the decade? And I want to start complicating the traditional view that most people have of the Warren Court versus the Burger Court, that the Warren Court was liberal and the Burger Court was conservative. I want us to start thinking about that. So we're going to talk about these 2 things separately. So first, let's talk about the Supreme Court's role in crime and crime control and the criminal procedure revolution. There are 2 stories that get told about the Supreme Court's role. One is told by liberals and one is told by conservatives. Both of these stories assume that the Supreme Court was central to some revolution, but they have different normative takes on what that revolution did and how salutary it was. So the liberal story is embedded in Gideon versus Wainwright, right? And this is the story told by Anthony Lewis. He actually wrote a whole book about this case called Gideon's Trumpet. It's a wonderful read. He's a journalist. It's not a scholarly work, and it was a huge bestseller, and it was an iconic book about the way the Supreme Court works. So what's the story? What's the story that Anthony Lewis is telling about the Supreme Court and American criminal justice and this revolution? What's Anthony Lewis's story? Jesse.
Triumphant idea that the Supreme Court cares about small citizens and families so much that the revolution
That's it, right? That's it. Triumph. It's a vindication of American constitutional ideas. The court is good. It cares about these small folks, right? And it creates change, right? Now, there are some indications in this story that maybe that's not exactly true. Josh points out 22 states are already on board with this, right? So how heroic, how counter-majoritarianly heroic is the court? One might say it's more so than you might think. It's mostly the southern states that don't have public defender services, partly because of race and who they imagine the criminal defendant is and who would benefit from public defender services. So one might say what the Supreme Court is doing is reining in outliers, not so much being outright counter-majoritarian. There's another way to complicate this story, which is, and I wonder what you think about this, right? So the story is Clarence Earl Gideon writes his letter to the Supreme Court. Someone somehow finds this pro se petition, and look what they do. They assign Abe Fortas, who's going to be a Supreme Court justice himself in the near future, to argue the case. It's not exactly how the story went. The story actually went that the justices had already decided the case of Douglas v. California. Anybody know what Douglas v. California is? It grants counsel for your first appeal of right. It's a follow-on to Griffin v. Illinois that I was just talking about before. So it grants counsel for your first appeal as of right. It'd be a little weird to grant counsel for an appeal when you don't get counsel for trial, maybe. And they have already decided Douglas before Gideon, but they don't release the Douglas opinion until after they decide Gideon, so that it looks like it came in the right order. Moreover, so they've been looking for a case that raises the issue in Gideon, and there had been an earlier case that they considered, but the defendant was so unsavory. I mean, Clarence Earl Gideon, right? Like, he's your regular drifter. He's a vagrant. But he's not evil. He's not awful. He hasn't done some horrible thing. So they had another case, and I don't recall the facts of it at the moment, but the defendant was so awful that the court wasn't quite sure which way they were going to go on it, and they didn't take that case. So they are looking for Clarence Earl Gideon. It's not just he brings something to the court and suddenly they see the light. Now, what do you think of that? Does that totally break down Anthony Lewis's argument? Does it totally undermine his argument, or is that fine? You can still make this claim. You can still tell this triumphalist story, even if those things are the case. Callie.
Well, I feel like something that's so central to like the traditional story is that like the weak individual gets like heard by the court and that, and I feel like knowing that they were looking for a case makes it seem like those in power were still just doing what they wanted to do, and they were using weak individuals to do like what they'd already planned. Like that he didn't really change anything.
That's so sad. Does anybody want to defend the triumphalist narrative against depressing hegemony? David.
I mean, I think it's a triumph of doctrine. I mean, you look at what's going on, sort of the overturning of Betts v. Brady, I mean, and sort of what you have with Johnson v. Zerbst, and I guess, was Black one of the dissenters in Betts v. Brady?
Yes.
So I think you have a sense of triumph in sort of this idea that's, the doctrine itself is a triumph. It's something that's been brewing for a while, and you have that going on. I mean, it's a triumph in the same sense that, Brown was a triumph over Plessy or something like that.
So Gideon himself doesn't necessarily have to be part of it to be a triumph.
No.
Okay. Other thoughts on that? Max.
Just to counter what Callie said, if anything, I think the fact that the Supreme Court is looking for a case goes the other way. I mean, these are legal elites who stand to reason don't benefit from the massive change in the status quo that the Gideon decision contemplates. Certainly as elites, they benefit from, in some way, from a harsher criminal justice. The fact that they're out there looking for a case to overturn the system in a way that is a huge lift to indigent or unfortunate defendants like Gideon. Seems that the court is looking out for the little guy.
Benita.
I would agree with that, and I think also it's one could say that there's a difference. The ACLU didn't find a test case here and bring it up. It still was someone who was writing to the Supreme Court, and whether or not they were going to find another case elsewhere, they didn't. They took his, and I still think that's a triumphant story.
He thought he had rights, and it turned out he did, right? He was wrong about the law when he first wrote, but then he was right. It changed. And there he is sitting in his prison cell, and 1,000 people are released from Florida prisons after this case, right? That's kind of big. But that's not to say, Callie, I'm not saying you're wrong. I think because I think there's lots of reasons to think like he's a tool, he's a pawn, but maybe he's both a tool and also an inspiration, right? Or maybe one says it requires both of these things, right? If the case doesn't come, if no Gideon Earl Warren or Clarence Earl Gideon Earl Warren, nice. If no Clarence Earl Gideon writes that letter, the court could wait forever, right? But it's also the case that the way the court works is not someone brings a case that's totally out of where the court's mind already is, and they're going to go for it, right? There needs to be some convergence between the kind of claim that he's making and things that are already within the legal elite discourse and categories that they're already thinking about, or it's unlikely to move forward all that much. And actually, we're going to see in the next, on Monday when we talk about poverty, we're going to see what happens and how claims get shaped to fit into legal boxes that maybe aren't that comfortable with them, and then what that does when you get to court. And I want you to think about that as you do the readings for Monday. Okay, so we've got the liberal story. What's the conservative story? The Chicago Mother's letter. What's the conservative story? Josh.
That the liberal old men on the Supreme Court chose to shape the law in the way that they wanted to and let crime run rampant in the streets.
Crime is crazy. Crime is crazy at this moment. I'll just give you a couple of statistics. In 1960, there were 1,800,000 crimes, according to the FBI crime statistics, which are notoriously flawed. But we're going to use those for all three of our things, right? So they're always notoriously flawed. Okay. So in 1960, there's 1,800,000 crimes. In 1970, there are 5,500,000 crimes. And by 1975, that number had doubled again. Crime is, in fact, going up, right? There's a perception and there's a reality. The rate of crimes is increasing, and a lot of people are blaming the Supreme Court for the rise in crime, saying you have handcuffed the police. The police can't do their jobs. You are letting criminals go free with this exclusionary rule, right? Yeah, maybe the cops shouldn't have searched them, but when they did, they found drugs and guns. How can you then let them go free? They were criminals, right? And this is where the battle between the crime control model and the due process model is joined, right? So adherents to the crime control model are responding to this and saying, you, the court, created this problem. Now, there are questions about what created the rise in crime at this moment. The baby boom meant that there were many, many, many more young people who are the people most likely to commit crime at this moment. Warren, what's Warren's theory about why there's so much crime? Ghettos and war, right? So ghettos is a huge part of why people think there's crime. LBJ creates this crime commission that ends up saying the reason we have so much crime is because we have concentrated poverty in ghettos. And Warren says these people, these young people, they know nothing but war. They know nothing but a devalued human life that we've taught them by being engaged in war all the time. But that said, many people think the Supreme Court caused the rise in crime. The Supreme Court did this. It is a very hard thing. And I say the role of the Supreme Court, I should have a question mark there too, right? We can't answer the question. We, in this class, can't answer the question. I'm not sure anyone can answer the question of what actually it was that the Supreme Court did on the ground, right? We know some things. 1,000 prisoners in Florida were let go as a result of Gideon. We know that police officers now read folks their Miranda rights. We know that counsel are now appointed. But we don't actually know how effective any of these things are, right? There are studies that show that reading someone their Miranda rights doesn't actually change the way anything happens after that moment. There are studies that show and cases that show in horrific detail the counsel that most poor folks get is pretty incompetent, and not all of it, but it often is, that they're overburdened, that they're not great lawyers, that they do an incompetent job. There's lots to show, there's lots to suggest that the liberal story is not true, in that whatever it is the court did up there, it didn't have salutary effects on the ground. We don't know whether it did. And by the same token, we don't know whether it had bad effects on the ground, which is kind of the flip side, right? The more the procedures actually protected criminal defendants, the more likely it was there were some criminal defendants who went free. Now, that's not to say the Supreme Court is on the hook for the entire rise in crime in this period, but who knows? We can't judge that, right? We can't judge that. But I just wanted to identify that the way the stories are told, both sides assume that the Supreme Court plays a huge role in both of these processes. And I think that that's an open question. The last thing I want to talk about today is Terry, right? And is the question of whether the Supreme Court's revolution, the Warren Court's revolution, is a linear one, whether they're still revolutionizing at the end of the Warren Court. Warren steps down in 1969. And what does Terry do? What do you make of Terry? How do you explain Terry? If Terry were decided under the Burger Court, no one would blink an eye, right? Why does Terry come out this way under Justice Warren, under Chief Justice Warren? Matt.
One could be that I think one of the reasons mentioned that there were riots in the cities in 1964 and 1967, so they're seeing the effect of crime. I think that is another thing is that when they're creating this federal system, they're making it so that all these local people have to have probable cause and have to go to procedure. And so now they also need to maybe give them some opportunity to at least do some investigatory work.
So they are seeing problems in the world. Are these problems of their own creation, you think? Do you think that they buy the story, they buy the crime? No. They just see the problems and they think we have to give the police tools to address these problems. Emma, you had your hand up?
Yeah, I think they're just sort of trying to appease the, law and order backlash while also, saying to the police you don't have, free reign. And also I think that, I thought that memo was interesting, and I felt they're sort of drawing a line between safety and sort of investigation. And I just think that's an interesting sort of dynamic of saying, well, you have the right to protect yourself, but you don't have the right to just nail anyone that looks like they might be
willy-nilly search them for everything. So that's a different kind of response, right, than Matt. So Matt takes them as thinking about the world and the police and trying to solve a problem. And Emma is a little more skeptical and thinks that they're politically responding to criticisms of them, right? That this is a more political response. Am I right?
Yeah, well, I don't think it's, I think it's a little bit of both. I think they see this problem and they see the reaction to the problem and they're responding to both.
Monica?
Well, I noticed that in the memo and in the case, they talk a lot about their own lack of efficacy. Like, the police are going to evade. In the memo, it says the police probably won't even listen, they're going to do this. And throughout Terry, the court's saying we recognize that we really can't control what's going on the ground here. We have limited control over it. So I think that's more in line with Matt, whereas they're sort of looking at the world and that sort of guide.
So let's take this and ask a question that we started talking about last time. When we talk about a case, there are lots of ways we can think about the case, right? And what you seem to be saying to me, tell me if I'm wrong, is they didn't actually think the case as a decision in the world was necessarily going to do all that much, right? That they don't have that much efficacy, but that they crafted the case expressively to offer up a vision. Is that what you're saying, right? So it's not only, because I think this is really interesting, right? It's not only that people outside the court think about a case differently. the justices think about the case differently. From the very moment Terry v. Ohio gets to the court, the outcome is not in doubt. It is clear from the very first conference that they have on this case that they are going to affirm this conviction. It is clear. And then the question is how, right? And one possibility of how is they're going to say there was probable cause. There's a probable cause standard everywhere. Probable cause is always the standard. We don't lose that standard, but it existed here. And the other possibility, so they don't go for that, right? The other possibility is to say, no, a different standard applies here. We're not under the warrant clause. We're under the reasonableness clause. And so a lower standard exists when the intrusion is less. When it's only a stop and frisk as opposed to an arrest and search, there's a lower standard. Now, that's what makes Douglas apoplectic, right? Douglas says, you can't do that. There's one standard. You can't do that. But the reason they do it is because they think if they keep probable cause, it's going to get watered down, the probable cause standard, and you're going to find probable cause everywhere. But they don't ever consider, if you do probable cause, it's going to water it down because there's not probable cause here. Because there is no way at this moment in 1968, with riots and Vietnam War protests and students taking over university buildings and crime on the rise, there is no way that they are going to reverse this conviction. That is clear, right? The case as decision was decided from the outset. They do not see any other possibility. The case as opinion, right? So one of the other possibilities is the case is an opinion, and we think about the legal reasoning of the case. That's very much on the table. Did you love Brennan's memo to the chief? He's like, Chief, I rewrote your whole damn opinion because it sucked. If I've offended the proprieties, please let me know, right? But in fact, Warren uses the Brennan version of the opinion, right? And Brennan, so let me stop for 1 second. So you have questions about the opinion. Is it going to be probable cause? Is there going to be a new standard? And they create this new standard. And people take note of that new standard. That new standard does have effects in the world and the way people think about police stops on the street. But then the next thing, which is what I think Monica was really talking about, is, well, so is the opinion as an expression of an imaginary that's not really satisfying. Is the opinion as reflecting some view of reality, right? And so one of the main things Brennan says in his opinion is not just I changed the legal basis of their opinion, I changed the tone, right? If we're going to give the decision to the cops, we have to give the rhetoric to the black people, right? We can't give both to the cops, because if we give both to the cops are going to go crazy. They're going to think we are wholly behind them, and that can't be. And it also means that all those people who are rioting in the streets because of conflicts between young African Americans and the cops are going to feel abandoned by us, and we can't let that happen either, right? So much of Brennan's concern is not with the decision, it's not with the analysis, although he is concerned with that. It's about the imagination of what the world looks like and how the world works that this opinion is going to provide. And then the fourth thing, right, so we talk about a legal decision, a legal opinion, a reflection of reality or an expression of an imaginary, and then the fourth thing is a political intervention, right? And this goes to what Emma was saying, right? They understand that the Omnibus Crime Control Act is happening. They understand that the 1968 election is a lot about the war on crime. They understand that they are getting the brunt of political criticism for their actions. And so they are pulling back and saying, no, 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 we are not going to completely tie the hands of the police. That's not what we're doing, right? So it's also a political intervention. So you can read the case on all four of these different levels, I think. Lyle.
I think Brennan gives the court a little bit too much credit because I'm not sure people rioting are going to care that the opinion's rhetoric is in their favor and just apply just your decision and then be upset. So I think that, I guess, maybe a little complicates where the case is and how far it extends. Because it's probably just a decision for the rioters and what the court says.
Is less important. So one thing I do want to make clear, though, and I think Emma says this too, is even though the decision is largely for the police, it's not entirely for the police, right? Because it's on the table as a possibility that the court will say anything short of an arrest and a search isn't even cognizable as a Fourth Amendment harm. And so one of the things that the court does do in this case is say it's cognizable. The Fourth Amendment covers these kinds of things. You can't just walk up to a person on the street as a police officer, start talking to them, and have nothing constitutionally restraining you. So they do give something, but it's still much less than what they give, I think, to the police officers. But you're right? They're concerned about what people are going to think. What people look, right? Who reads? How far does this go? What? And that goes back to the role of the court, right? So what role is the court playing? What do people think of the court? Where did Gideon get his idea that he had a right from? Where did that come from? And he didn't have it quite right? But he had one. He wasn't that far off. Bets give some rights. So where does it come from? Does it come from the opinions? Does it come from newspaper coverage of the opinions that might reflect the rhetoric, right? How does it disseminate out, and how do people then understand what it is the court's doing and what their rights are under the Constitution? Last comment, Trevor.
What I thought was interesting was Brennan doesn't foresee that by grounding it in the reasonableness clause, you open it up for textualists till 30 years later, because there's some commentary now that the liberals are trying to resist any search and seizure case coming before the court until they get another liberal justice on the court. Because Scalia has recently been grounding some criminal procedure opinions in the same reasonableness standard that Terry elucidates.
Right. So, and that's a point.
All the previous warrants.
So that's a point that is a more general point that is very important, right? Which we talked about in Brown, which is the point of unintended consequences, right? You use a new frame, you create a new category for a particular purpose at a particular moment, and then that category and that frame is available for future litigants and future courts to reshape and reframe in new contexts on behalf of new litigants, right? That's part of the process of what happens in constitutional history. All right, we're going to go. It's time, but let me just say one last thing. I'm going to leave you with a question. So the question is, I want you to abstract from this story that we've been talking about today, and particularly the last question about the role of the court, to abstract about the way the court interacts with states, state courts, state legislatures, other branches of the federal government, public opinion, actual change, right? So does this story look like a Lochner story? Is the court counter-majoritarian, and then finally in Terry it realizes it shouldn't be counter-majoritarian at all anymore, and then it's not, right? And it capitulates to public opinion. Is this a story that is in fact the court following public opinion, like the briefs that the 22 states submit in Gideon? And so it suggests Barry Friedman's view that the court never gets that far from public opinion, and really what it's doing is reining in outliers. How would you think about this episode in American constitutional history, and what other episodes it looks like, right? So starting to think across topics and across time periods to see what role the court is playing, and how its role is similar or different from its role in other instances. All right, thank you, everybody. I'll see you on Monday, and we will talk about poverty in the Constitution.